Good morning, this is your Kelso Report for Thursday, August 30th. I'm your host, Clark Kelso. We begin today with a case involving procedural due process. A property owner lost a state administrative appeal where the owner had challenged the Orange County tax assessor's valuation of a parcel of real property. The property owner then filed suit in federal district court, alleging that its procedural due process rights were violated in the course of the administrative appeal hearing because the county counsel's office represented both the assessor and the county board of equalization. That was the ultimate decision maker. In Jefferson and Company versus Board of Assessment, the Ninth Circuit rejected the property owner's due process challenge. Now, according to Government Code Section 31,000.7, the same law firm shall not be employed to advise or represent both the assessor and the County Board of Equalization on any matters relating to hearings before the County Board of Equalization. This prohibition shall not apply to the County Counsel's office. Individual representatives of that office may represent the assessor and the County Board of Equalization as long as the same individual does not represent both parties, close quote. That's all of Section 31,000.7. So the statute clearly permits this type of representation. Well, according to the property owner, having the county counsel's office represent both the assessor and the adjudicator was unfair and created an appearance of unfairness, violating procedural due process. But the Ninth Circuit reasoned that as long as the county counsel's office maintains an ethical wall that prevents attorneys representing the assessor from supervising attorneys who advise the board or sharing case information with them, the county counsel's dual representation does not undermine the board's impartiality. Next, we have an intellectual property case involving the doctrine of latches. In 2009, the plaintiff filed an action for copyright infringement, unjust enrichment, and accounting against Metro-Goldwyn-Mayer, alleging that MGM had infringed her purported interest in a book and 2 screenplays that together allegedly formed the basis for the 1980 motion picture Raging Bull. The district court granted summary judgment in favor of the defendants, holding that plaintiffs' claims were barred by the equitable defense of latches. In Petrella v. MGM, the Ninth Circuit affirmed. Unlike many other circuits which only let defendants raise the copyright law's 3-year statute of limitations as a defense, the Ninth Circuit has previously held that a defendant can also interpose a latches defense. Now, as I'm sure you all recall, latches is an equitable defense that prevents a plaintiff who, with full knowledge of the facts, acquiesces in a transaction or has knowledge of an injury, and nevertheless sleeps upon his or her rights. In particular, a successful latches defense requires a showing that, number 1, the plaintiff delayed in initiating the lawsuit, number 2, that delay was unreasonable, number 3, the delay resulted in prejudice. Moreover, if any part of the alleged wrongful conduct occurred outside of a statute of limitations period, courts presume that the plaintiff's claims are barred by latches. Well, the statute of limitations for copyright claims in civil cases is 3 years. The violation allegedly occurred in 1980 with a release of the motion picture, and suit was filed 29 years later, in 2009. The latches delay clock begins running when the plaintiff knew or should have known of the allegedly infringing conduct. Arguably, that clock began in 1980, but the court and the parties agreed that certainly as of 1991, when her attorney filed her renewal application for her 1963 screenplay, she was actually aware of her potential claims. The plaintiff had no acceptable reason for any subsequent delay in bringing the lawsuit. She explained that the delay was caused by her brother's disability and her mother's illnesses that over a period of years required her attention and care. her mother's fear of retaliation from the defendants, her family's inability to afford a lawsuit, and the fact that the film had not produced enough revenues to make a suit worthwhile. The Ninth Circuit rejected these reasons as a matter of law, found the defendant had continued to invest in marketing the movie and thereby had been prejudiced by the delay in filing suit, and affirmed the dismissal of plaintiff's lawsuit under the doctrine of laches. Next, we have a habeas corpus decision in a death penalty case. The petitioner in Ayala v. Wong appealed the denial of his petition for a writ of habeas corpus. During the selection of the jury that convicted him of murder and sentenced him to death, the prosecution used its peremptory challenges to strike all of the black and Hispanic jurors available for challenge. The trial judge concluded that the defendant had established a prima facie case of racial discrimination under Batson v. Kentucky, but permitted the prosecution to give its justifications for the challenges of these jurors in an in-camera hearing from which the defendant and his counsel were excluded. The trial judge then accepted the prosecution's justifications for the strikes without disclosing them to the defense or permitting it to respond. Now, the federal habeas corpus review was hampered by the fact that a large portion of the trial court record had ultimately been lost and was therefore unavailable to the federal court. A split panel of the Ninth Circuit held that the procedure adopted by the trial court, excluding defense counsel and the defendant from the hearing on the Batson challenge, violated the Constitution and, in the unusual circumstances presented, required reversal and an order directing the district court to grant the writ of habeas corpus. I think this is going to be a close case for Supreme Court review. The majority opinion is by Judge Reinhardt. That will attract some attention by the Supreme Court conservatives. And Judge Callahan has a strong dissent, which notes that the majority essentially presumed that the prosecutor's strikes were unconstitutional. The decision may be saved by the fact that the exclusion of defense from the Batson hearing seems to have been a pretty extraordinary error, and the loss of the record makes any type of subsequent review problematic. We'll see what the Supreme Court does. Next, we have an important immunities case coming out of Arizona. It's tough being a reporter in Maricopa County, Arizona, particularly if you publish stories critical of nationally known Sheriff Joe Arpaio. Over a period of several years, Arpaio targeted the publisher of a newspaper that had run stories purporting to expose allegedly improper financial dealings by Arpaio, and had published Arpaio's home address in a story, seemingly violating a statute by doing so. Ultimately, largely because of Arpaio's pressure, a special prosecutor was appointed to investigate the newspaper, and the special prosecutor, without consulting with the grand jury or a court, issued subpoenas for the arrest of the two publishers. The local court ultimately threw out the subpoenas and the arrests, concluding that the special prosecutor had acted ultra vires in issuing them. Well, the publishers, of course, sued the special prosecutor, Arpaio, the county, and a few others in federal court under Section 1983, alleging primarily that the defendants violated their First Amendment rights by investigating and arresting them in retaliation for articles published in their newspaper, and with the purpose of suppressing the exercise of their First Amendment rights. The problem here is that prosecutors generally enjoy absolute immunity for their prosecutorial conduct, including conduct before grand juries, because that conduct is integral to the judicial phase of the criminal process. However, the Ninth Circuit had no trouble in this case in holding that this immunity did not apply on the extreme facts presented here, given that the special prosecutor acted ultra vires when he issued the subpoenas without ever obtaining grand jury or court approval. And that's it for today's Kelso Report. There are a number of state law cases today that were of interest. I'll pick those up in tomorrow's report. Have a great day in the law.